Good morning, Alexandra Lopez, immigration attorney here. It is Monday, November 18th, and there's been a policy update on the USCIS site regarding admissions and naturalization. So essentially, there was a case, Azuma versus USCIS, where a Ghanaian national was denied his petition for naturalization based on being deemed inadmissible after he had gotten his green card. Now, essentially, the decision in the Fourth Circuit, it was appealed, right? Stated that for the purposes of an applicant naturalization, when USCIS is determining whether that applicant has been lawfully admitted for permanent residence, they are only to look at the initial admission prior to obtaining permanent residence. So in this case, this individual from Ghana had been admitted in 2010 as a permanent resident. He was later convicted of a crime and he left the US. He traveled to Ghana and then he re-entered in 2014. And at that point, he was paroled into the country because he had been deemed inadmissible due to his prior convictions. He later on applied for U.S. citizenship, and USCIS denied his citizenship application. Sorry, I'm looking at my notes here. They said he was ineligible because he hadn't been lawfully admitted for permanent residence based on his 2014 entry, not his initial entry. The federal district court upheld that ruling, and then the Fourth Circuit Court of Appeals vacated the district court's judgment, and they've said that he maintained his LPR status and that the requirement to be lawfully admitted for permanent residence only pertains to the initial grant of permanent resident status, not subsequent entries. So in his subsequent entry, he was paroled in, and the question might be, well, if I was paroled in prior to getting adjustment, does a parole not count as a lawful admission? And that is not what the case states, okay? So I've gotten some questions about people going to apply for advanced parole and later do, the permanent resident adjustment of status process. And the case is not stating that parole is not a lawful admission. Okay, they're just saying that in this case, you don't need to evaluate every single reentry after that initial one. So I hope this clarifies it. If I were you and I am eligible for advanced parole, I would still seek advanced parole and not actually be concerned about how that affects naturalization in the future, because it's at the time that you seek permanent residence that they're evaluating that lawful admission.